Committee on Oversight and Government Reform will come to order as previously ordered. The presiding member is authorized to declare recess at any time. This is a continuation of a hearing that we began last week for reasons that still confound me. Today's witness was not here last week. I think it would have been more convenient for you, and I know it would have been more convenient for the members, but I don't run the department. So for whatever reason, you weren't here last week, you're here this week. With that, I'm going to have to administer an oath because that is what we do for all witnesses. So if you would please stand and raise your right hand. You solemnly swear the testimony you're about to give should be the truth, whole truth, nothing but the truth, so help you God. May the record reflect the witness is answered in the affirmative. With that, we are pleased to introduce today's witness, Mr. John Gore, who's the Acting Assistant Attorney General for the Civil Rights Division of the United States Department of Justice. You are recognized for your 5-minute opening statement.
Good morning, Chairman Gowdy, Ranking Member Cummings, and other distinguished members of the committee. The Department of Justice recognizes this committee's important oversight role, and on behalf of the department, I thank you for allowing me to appear today. The committee originally invited me to appear last week on May 8th as part of a panel with 4 other government witnesses from the Department of Commerce and the Census Bureau. I accepted that invitation, but in the days leading up to last week's hearing, the committee informed the department that the committee had added a non-government witness to the panel. It is long-standing Department of Justice policy and practice to decline participation in committee hearing panels that include a non-government witness, particularly when the department is involved in litigation regarding the subject matter of the hearing. Accordingly, before last week's hearing, the department reached out to the committee and offered several accommodations that would have allowed me to provide testimony last week. Those accommodations included moving the non-government witness to a separate panel, allowing me to submit written testimony and written responses to questions for the record, or postponing the hearing. The committee denied those accommodations. The Assistant Attorney General for Legislative Affairs, in consultation with department leadership, then made the decision on behalf of the department that I would not appear at last week's hearing. After further consultation with the committee this week, the department has decided that I would appear voluntarily today without any non-government witnesses and without the committee issuing a subpoena. The Department of Justice is resolutely committed to the full, robust, and even-handed enforcement of the nation's civil rights laws and to free and fair elections on behalf of all Americans. The department's mission is to ensure that all Americans have a full and equal right to vote, regardless of race, color, language, or military service. And we are fulfilling that mission all across the country. Since January of 2017, the Department of Justice has participated as a party in 3 cases under Section 2 of the Voting Rights Act, and we have resolved 3 other cases under the National Voter Registration Act. Those 3 resolutions ensure that eligible people will be able to register to vote and remain registered. The department has participated as an amicus in 3 voting rights cases, including another Section 2 case and a case seeking to protect the voting rights of members of a language minority group in one of America's largest cities. The department has continued our election monitoring program and our outreach and enforcement efforts under Section 203 of the Voting Rights Act, which protects the rights of language minorities. The department is also zealously protecting the voting rights of our brave men and women in uniform and other overseas citizens through the Uniformed and Overseas Citizen Absentee Voting Act. In 2017 and 2018, the department assisted several states in achieving compliance with UOCAVA for their special elections. And in February of this year, the department filed and resolved a voting rights case under UOCAVA involving the state of Arizona. The department is gearing up for the 2018 elections as well. We are working day in and day out to ensure that those elections are conducted in accordance with federal law requirements. In furtherance of the department's ongoing commitment to the fair and full and even-handed enforcement of the nation's voting rights laws, on December 12, 2017, the department sent a letter formally requesting that the Census Bureau reinstate onto the 2020 Census questionnaire a question regarding citizenship. That question previously appeared on the short form of the census and the long form of the census, and it currently appears on the Census Bureau's American Community Survey. The department's letter explained that accurate citizenship data is crucial to the department's enforcement of Section 2 of the Voting Rights Act and its important protections against racial discrimination in voting. To fully enforce those requirements, The department needs reliable citizen voting age population data in localities and census blocks where voting rights violations are alleged or suspected. Since the department submitted its letter, 4 lawsuits have been filed challenging the Department of Commerce's decision to reinstate the citizenship question onto the census questionnaire. The Justice Department is defending those lawsuits. In deference to the courts charged with adjudicating litigation involving the United States, the department's longstanding policy and practice is to decline to make statements regarding that litigation outside of court. The department accordingly is constrained in its testimony today. As I said at the outset, the department takes this committee's oversight role very seriously, and our goal is to be as responsive to the committee as possible. But in light of the pending litigation, the potential effect any public statements might have on ongoing court cases, and the department's litigation constraints, I am unable to make any statements today beyond those in the department's letter and other publicly available information. The department thanks the committee for its understanding of these constraints. Thank you.
The gentleman from Wisconsin is recognized.
We'll give you a few questions here. What data does the Civil Rights Division receive from the Census Bureau?
The data we receive from the Census Bureau, Congressman, there are 2 different forms of data we receive from the Census Bureau. We don't receive any individual responses to census questionnaires, whether that's the decennial census questionnaire or the ACS questionnaire. What we receive is aggregations of statistical data that compile the individual answers into statistics for geographic areas.
Give me an example of how you use that data.
Sure. So, for example, in our Section 2 enforcement work, we need information at the census block level. The census block is the smallest unit of geography that the census collects data on. For example, the Census Bureau's information says how many people live in the census block and what their race is, which is important for Section 2 of the Voting Rights Act. And then the ACS data provides estimates of citizenship rates, but not at the census block level, at either the block group or tract level.
So you really have to know if anything was going on, the amount of people there who are legal and illegal, correct?
For our purposes, in the Civil Rights Division, what's important to know is racial data and citizenship data at the census block level. And currently, we don't receive census citizenship data at the census block level. That has to be extrapolated from ACS estimates, which are only available for larger geographic units.
And give me a hypothetical why that matters. Give me
Sure.
an example of a situation.
Sure. So the easiest way to think about it, Congressman, is that a census block is the fundamental unit of a district.
And so we know just how big is the census block? Maybe, I'm sure it varies greatly, but
It does vary greatly. Think about it as maybe a city block or a suburban block, and the population of census blocks can vary all across.
10 houses maybe.
Could be.
Yep.
Could be a single apartment building.
Yep.
And what a redistrictor has to do is collect a number of census blocks to form a district. And so the census block information gets aggregated up to the district level, and that's how you know how many people are in the district for one person, one vote reasons. It's how you know the racial composition of the district for voting rights reasons as well. And so the citizenship data is crucial because in many Voting Rights Act cases, you need to know citizenship rates to understand whether the district is performing for a particular minority group.
I'm trying to think how it would even come into play. Let's pretend we got a block of 10 houses, and in those 10 houses there are 23 adults, and 5 of them are illegal, and I really don't like, I hate the idea of labeling people by race, because I think there are other ways to label people, but I guess that's what we're obsessed with here. And let's say of those 23 people, 6 people are a minority, of which 2 are the illegals and 4 are citizens. What do I do with those data? How would that possibly come into play? What are you going to do with that data?
Sure. Thank you, Congressman. Thank you for your question. What we would do with that data is we would analyze the district to determine whether it complies with Section 2 of the Voting Rights Act or suggests a Section 2 violation in that geographic area.
How would it comply or not comply?
Section 2 requires, it prohibits what's called vote dilution. And so in certain circumstances, Section 2 requires redistrictors to draw districts that have a majority of a minority group within the district that can elect its candidate of choice. That's a fundamental protection of Section 2 of the Voting Rights Act. So once you've put together the census blocks and aggregated the census block information on the district level, you know whether you have a Section 2 district or a Section 2 problem. Because it may be that a map drawer has split the minority group into 2 different districts or has otherwise manipulated district lines to violate Section 2.
Just a second, and I know you're not the one who drafted the law. Isn't there an assumption there, a little bit of an assumption, that people, when they go to the polls, rather than being, I would argue, intelligent people and voting on people's candidates' opinions on transportation or education or taxation or whatever, that people are expected to vote for people by race?
I don't believe that's an assumption. One of the fundamental requirements in a vote dilution case is to show that there's racially polarized voting, and that doesn't exist everywhere in the country, but where it does exist, Section 2 can be triggered in a vote dilution case. And racially polarized voting refers to members of a racial group tending to vote together for the same candidate.
Okay, I think that's a very inappropriate assumption, and maybe we should look at the law sometime, because I would hope there are a lot of Americans who just go to the polls and vote for someone of their same racial background. But thank you for.
Gentleman yields back. The gentleman from Maryland is recognized.
Mr. Gore, I read your written testimony, and you seem to be saying that you will not answer Congress's questions. Certain questions. Let me read exactly what you said. I will be, quote, I will be unable to make any statements today beyond those in the Department's letter or other publicly available information. You claim you cannot answer our questions because the government is being sued. Mr. Gore, the government gets sued all the time. Would you agree? Come on.
Yes,
all the time.
I would agree.
Are you really suggesting that this committee's jurisdiction ceases to exist because you happen to be involved in litigation with another party?
Congressman, what I'm here to say today, thank you for your question, by the way.
Sure.
The Department does take very seriously this committee's oversight role, but it's the longstanding policy and practice of the Department not to comment on litigation outside of court.
Mr. Gore, the state of New York has sued the government. The state of California has also sued the government. You don't tell California it has to stand down because New York sued it. They are both independent entities, and so are you. So are we. Mr. Gore, Congress is an independent branch of government, an independent branch. We have a job to do. We conduct parallel investigations all the time. We're not asking about your litigation. We're not asking about motions your attorneys might make or about work product they are developing in those court cases. We are investigating the underlying facts. How and why did you and the political appointees at the Justice Department come to ask the Census Bureau to add a new untested citizenship question to the census? That is our job under the Constitution. That's why we want you here. Your job is to answer our questions. So let me ask you this. Please tell us what your specific role was in the entire process. Describe how the decision was made at the department to send this letter with this specific request, and tell us who else at the Department of Justice you communicated with throughout the process.
Congressman, I appreciate the question, and as I said before, the Department recognizes and acknowledges this committee's important oversight role. The Department of Justice is an independent part of the independent executive branch of government. We have an independent constitutional obligation to take care that the laws of this country are faithfully executed, that the laws that this Congress enacts are faithfully executed in a fair, even-handed, and robust manner all across the country. As part of fulfilling that mandate, the Department of Justice has a longstanding policy of maintaining confidentiality in its deliberations and its decision-making in order to facilitate robust, open discussion of decisions before they're made, so that people can express their viewpoints, so that decision makers can make the best possible decisions they can make. That's similar to the process the Congress goes through with members of its staff. You've asked me questions about a decision-making process and internal deliberations at the Department of Justice, and I'm not in a position to answer those questions today.
Mr. Gore, a major decision, I only have a little bit of time. Mr. Gore, a major decision like this one must have gone to the Attorney General. Did you or anyone else speak directly with the Attorney General about this idea? And if so, what was the substance of your discussions with him?
Congressman Cummings, as I've said, the Department of Justice has an important role to play. We have an important independent role to take care that the laws are faithfully executed.
I asked you, did you talk to your boss?
Congressman, I'm not going to discuss any internal communication.
You mean you can't tell me whether you talked?
Decision making.
Wait a minute. Whoa. You mean you're going to tell me that you didn't talk? You can't answer a question as to whether you talked to your boss, who we pay?
What I'm telling you, Congressman, is that I'm here today to talk about the Department's letter and its public decision and the letter it sent to the Department of Commerce. I'm happy to discuss any public information regarding that. What I'm not in a position to discuss today is anything that may or may not have happened.
Okay, I know you're going to rope it on me. You must have consulted with the head of the voting rights section of Justice. What was the substance of that discussion?
Congressman, again, we facilitate open and robust conversation in the Department of Justice.
Did anyone, you're going to say the same thing, right? Are you going to say, because we don't have time, you're going to say the same thing? Just say yes or no. Can you answer that?
Oh, I'm sorry, what's the question, Congressman?
No, that's all right. Did anyone at the Department of Justice ever raise concerns internally about going forward with your plan?
Congressman.
Same answer? Is that the same answer?
It's the same answer.
Okay. Did you talk to anyone outside of government about this idea? For example, did you talk to Chris Kobar, or if so, what was his substance of those discussions?
Congressman,
did you talk to him about this?
To who?
Chris Kobar.
No.
Okay. Mr. Gore, there's a difference between investigating the facts of an incident and investigating how the Justice Department plans to litigate those facts in court. We're only asking about the first. Will you or will you not answer these questions in full?
Congressman, I stand by my answers.
One last thing, Mr. Chairman, with your indulgence. You say you cannot answer our questions because you are worried about inconsistent statements. Is that basically what you're saying?
That's part of the concern, Congressman.
Okay, that's fine. Just tell us the truth. That's all I want is the truth. You have that obligation every time you appear before any judge. You have that obligation right now, right here, and you're not going to answer. Is that right?
I'm answering truthfully, Congressman. This is the Department's longstanding policy and practice.
Thank you, Mr. Chairman. Thank you for your indulgence.
Gentleman yields back. The gentleman from Alabama is recognized.
Thank you, Mr. Chairman. One of my concerns about this whole issue of how we count the census and have a distinction between counting people who reside in an area versus those who are citizens, I think is very important in the context of apportionment. After the census, we're anticipating a number of states are going to lose representatives. Illinois will very likely lose multiple representatives: Michigan, Ohio, New York, Pennsylvania, West Virginia, Rhode Island, Alabama, possibly Minnesota. In the context of what we're trying to do with the census, obviously we've got to count everybody. We need to know how many people live within our borders. But in the context of apportionment, it seems to me it'd be extremely important to know how many of those who reside within our borders are citizens. Can you comment on that?
Thank you for your question, Congressman. I think that is a very important question and a very important issue. It's not one that the Department of Justice has taken a position on. What our letter speaks to is our enforcement activities under Section 2 of the Voting Rights Act, not the separate question of how congressional seats are apportioned across the country under the Constitution.
But with that in mind, though, I'm just trying to think about this in the context of what we intended with the Constitution and how our government functions. we are a nation of sovereign states who elect representatives to come to Washington to represent them. It doesn't impact how many senators we have, but it definitely impacts the number of members that will represent a state in the House of Representatives. It impacts federal funding for state projects. And I just want to know, I'm not sure that you can answer this, but I think it's important to kind of flesh this out in the context of all this, is that it seems to me to be, at its basis level, unfair for one state or 2 or 3 states to have, perhaps declare themselves sanctuary states, which I would think tends to attract people who are not citizens, and then have those people counted, and then in apportionment actually have more representatives than a state that has among its population almost all legal residents. Just in a sense of fairness, it would seem that we need to know who are citizens and who aren't.
I think you've raised several important issues in your question, Congressman. I'm generally aware that the Congress has enacted statutes that take citizenship into account for various federal programs. I don't administer those programs, and I don't know the specifics, and the Department hasn't taken a position on any of those programs. We've explained why we think this data is necessary or would be preferable to have through the census at the census block level for our Voting Rights Act enforcement. But I think you've raised several good questions that the Congress should deliberate on and make an appropriate decision on its own.
Well, we take very seriously the voting rights. No one eligible to vote should be denied their right to vote. I don't think we take it seriously enough when people cheat in elections. When people who are not eligible to vote, when the dead vote, for instance. There are a lot of jokes about that in certain parts of the country. But I think we also got to look at it. Again, I'm going to keep pounding on this because I think that this is important. And it in no way diminishes the potential for people who are not here legally or who are not citizens having the opportunity sometime down the road to become citizens and be legitimately counted for apportionment purposes. But I think there's a fundamental problem that we need to address here, particularly with some states that are giving sanctuary to people who are here illegally, in violation of federal law, by the way, and then have those people counted and it have an impact on apportionment. And then you have a number of states losing representation in Congress for various reasons. Alabama is not a state that's losing population. Our population has increased, but we very likely will lose a representative. And I just think, Mr. Chairman, that's a major problem that I think we need to address. Thank you for you being here, Mr. Gore, and for responding to my questions. I yield back.
Gentleman yields back.
Would the chairman entertain an inquiry?
Pardon me?
Would the chairman entertain an inquiry?
Sure.
It has been asserted that the Department of Justice has a longstanding policy not to cooperate with respect to documents involving deliberative process. Is it an accurate recollection by this member that when, for example, we conducted the Fast and Furious investigation, we in fact received many documents that reflected the deliberative process of that Department of Justice, and that, as a matter of fact, the Department of Justice cooperated with the provision of such documents, that there is, in fact, precedent?
The gentleman's point is well taken. In fact, the ranking member and I were just discussing yesterday the relativism that sometimes exists in how we investigate matters and how we view privileges and how we handle ongoing litigation, ongoing Inspector General investigations. What I can tell my friend from Virginia is, while I am happy to make a Department of Justice witness appear, I cannot make that witness talk. You can get Jack Bauer to come preside over this hearing, and perhaps he could, but I cannot make someone talk or produce documents.
I appreciate that, Mr. Chairman. I simply wanted to establish for the record that the assertion that it was longstanding Department of Justice policy is in fact not correct, that we have an example, a major example in this committee with the previous administration of the very opposite of what has been asserted by the witness.
My friend from Virginia has put his finger on something that exists on both sides of the aisle and has existed no matter which administration happens to be in power. I'm not a fan of relativism, no matter where it manifests itself.
I thank the chair.
The gentlelady from New York is recognized.
Thank you, Mr. Chairman. And I'd like to follow up on the questions of Ranking Member Cummings. Mr. Gore, your refusal not to answer the questions of Ranking Member Cummings, I find, and I believe all of my colleagues find, unacceptable. We conduct parallel investigations all the time. Every day we conduct them. If we had to shut down our investigations every time a federal agency got sued, we might as well all just resign and leave, because investigations take place every single day, and we are sued every single day. You were supposed to be here last week, and with all due respect, I do not understand why you refuse to be here, but you're here today, and at the very least, you should answer questions. And I'd like to begin by referencing what happened on May 16th. Just 2 days ago, Tom Brunel, President Trump's first choice to be the Census Director, gave an interview. And in that interview, he said that the administration's decision to add this citizenship question was based on politics, not on science, not on best practices, but he said based on politics. And I quote, "They have made a political decision, and they have every right to do that because they won the election." End quote. Now, I find that appalling. He is basically admitting to politicizing the census, and it contradicts the wording of our Constitution that says every person should be counted. So, Mr. Gore, I want to know everyone who had a role with you in this deliberation and this decision, both inside the Department of Justice and outside of the Department of Justice.
Thank you for your question, Congresswoman Maloney. Let me just...
Well, will you give us the names today?
Let me reiterate what I said in my opening statement, which was that I accepted the committee's invitation to appear last week, and it was only after the committee added a non-government witness to the panel and denied the accommodations that the Department of Justice requested that the department made the decision that I would not appear last week. And I'm happy to be here today and answer your questions. Let me speak to the issue about Mr. Brunel for just a moment. I can't speak for Mr. Brunel, but as you point out, Mr. Brunel is not a member of the Department of Justice. He is not a government official in this administration. He doesn't speak for the Department of Justice. He doesn't speak for the Civil Rights Division, and he doesn't speak for me. I don't know where Mr. Brunel is drawing that conclusion from. I don't know what information he could possibly have as someone who was not involved in the decision and is not at the Department of Justice, the Department of Commerce.
Well, did you communicate with Mr. Brunel on this issue? Did you communicate with him?
No, I did not.
You did not. Did you or anyone else at the department communicate with anyone, a political organization such as the RNC, the Redistricting Commission, the Trump campaign, anyone else? Who else did you consult on this decision?
I can tell you, Congresswoman, that I didn't consult with any of those organizations. I can't speak for other people. They'll have to speak for themselves. And in terms of people I may or may not have consulted with within the Department of Justice or within the executive branch, my answer is the same. Those conversations and deliberations and decision-making are things that I'm not in a position to comment about today, both as a matter of department practice and policy and because there's pending litigation on this issue.
Are you, Mr. Gore, are you asserting a constitutional privilege here today?
I'm not authorized to assert any privileges.
Okay, are you asserting the Fifth Amendment or executive privilege?
I have no basis to assert the Fifth Amendment, Congresswoman Maloney. I've done nothing that would put me in any kind of criminal jeopardy for anything. I would never do anything unlawful or illegal, and the implication that I would is baseless. I am not
Thank
asserting
you
any
very
kind of
much.
privilege.
Since you're not answering any questions, I'd like to thank the chairman for bringing him here today, but I'd like to quote the chairman's statement that he can bring him here, but he can't get him to answer any questions. So, Mr. Chairman, I have a motion, and with all due respect, I should have done this last week. I plan to formally offer a motion under the rules, give my statement, and seek a vote, and this motion is in order. And I would say that the key issue for the meeting today is the Trump administration's sudden decision to add a new citizenship question to the census, untested and at the last minute. This decision was made at the request of the Justice Department. They sent a letter in December claiming they needed this data to enforce the Voting Rights Act. But this data has never been needed since the act was passed in 1965. According to documents released through the Freedom of Information Act, this request made at the request of leadership working with John Gore, our witness today, and I would ask unanimous consent to place these documents into the record.
Without objection on the placing of documents in the record.
So Mr. Gore is the acting head of the Justice Department's Civil Rights Division for the Trump administration. Now, you are the acting head of the Department of Civil Rights Division, but I don't know of any record of yours in this area. But I do know of the record where you defended Republican state redistricting plans, including one dismissed for racial gerrymandering. He also defended a voter purging effort that violated the National Voter Registration Act. And on May 8th, Chairman Gowdy sent a letter inviting Mr. Gore to testify, but he failed to appear last week. And at that hearing, I had a motion to subpoena Mr. Gore. Instead, the chairman recessed the hearing, resumed it today, and brought Mr. Gore in to answer our questions. The problem is, Mr. Gore is not answering our questions. Right now, Mr. Gore is here voluntarily, so he is not legally compelled to answer any of our questions. So I move that the committee subpoena Mr. Gore right now, like we should have last week. We have a process, Mr. Chairman. You may not want to issue this subpoena, but our committee has authority under the rules to vote on a subpoena to compel Mr. Gore to answer our questions today. Not tomorrow, not next week, but today. And Mr. Gore then would be required either to answer our questions or assert valid constitutional privilege. If Mr. Gore continues to refuse to answer our questions, or if he asserts a privilege that is not valid, this committee could hold him in contempt. So I want to make one thing clear. We are not asking you one word about litigation. We are not asking about any of your briefs or anything that your department is involved in, your motions, your attorneys, or the work that they are doing. We are asking about the underlying facts, and we have every right to ask about them. It's our responsibility to ask about them. And we have an independent responsibility to investigate, and that is what we need to do today. These underlying facts already exist. Congress and the American public deserve to know them, and there is absolutely no legitimate reason for you to keep silent about them. Congress handles parallel investigations all the time, and this is no different. This is a parallel investigation. Our oversight responsibilities do not cease to exist because someone sues the government. The government gets sued multiple times every single day. For all of these reasons, I hereby move to subpoena John M. Gore, the Acting Assistant Attorney General of the Civil Rights Division at the Department of Justice.
I second the motion.
I make this motion pursuant to House Rule 11, Clause 2K6. We have spoken to the parliamentarian's office, and this motion is in order. I spoke with them myself. A written copy of my motion and the subpoena is at the clerk's office, and I ask that the chairman dispose of this motion right now so we can start getting answers to our questions.
On the motion?
Reserving a point of order. For what purpose does the gentleman from Alabama seek recognition?
Mr. Chairman, I move to table the motion, and pending that, note the absence of a quorum.
Gentleman is correct. Quorum is not present. The motion to table is made. The motion to table and debate on the underlying motion are held in abeyance until sufficient quorum is present. Out of respect for the witness, I think we should proceed with the hearing until that time.
On a point of order, Mr. Chairman.
Gentleman state his point of order.
Would the would the subpoena that is subject to the motion to table, would that include a request for documents as well as a subpoena for the person?
I don't believe so, but since it's not my motion, I might defer to the.
I have a copy of it here, but it's blank. It doesn't.
I think it is a subpoena for personal attendance as opposed to one for documents. But again, given the fact that it was not my motion, I'm reluctant to speak to it at length.
All right. Thank you, Mr. Chairman. I yield back.
Well, would the gentleman yield to me? Okay. Thank you. With all due respect, Mr. Chairman, we have a number of members here. We would like to have our questions answered, and to delay this, to table it, to postpone it, it makes absolutely no sense. Why are we asking questions when the witness has already told us he's not going to answer any of them? So it seems like we should address the subpoena. It's ready to go. We talked about it last week. You said he'd getting him in. He's in. It's not your fault, but he's refusing to answer questions. So it seems like it's very appropriate that we should move forward with the subpoena so that we can get answers to our questions. This is, you know, that the census is really the only it's a requirement. It's written right in the Constitution that the executive branch must conduct it every 10 years. It's a very serious issue. It is the basis of our democracy, our representation. It makes the decision on the distribution of really over, I'd say, $700 million in federal funds every year. It's a very, very critical issue. And we deserve to have our answers today, and I respectfully request that the chairman move forward with the subpoena request. And I yield back.
I'll address the gentlelady. I've been uncharacteristically liberal in my allowing her to exceed the 5 minutes to address it. I think it's an important point, but nonetheless, quorum is not present. So out of respect for the witness, until the quorum is present, continue to ask whatever questions he is able to answer. And with that, I would I'll recognize my gentleman from Virginia, Mr. Connolly.
Thank you, Mr. Chairman. I would say to my colleagues on the other side of the aisle, while I respect the right of my friend from Alabama to move to table a motion to subpoena, you will significantly cloud the legacy of this committee in asserting the principle of accountability and the separate but co-equal branch of government role. I sat here and watched the Fifth Amendment rights of Lois Lerner be trampled upon. I sat here and watched the same committee want to censor the Attorney General of the United States because of their perceived view of lack of cooperation. But apparently it's a whole different set of rules if it's a different administration that happens to be of your party. And I just think that's a very sad day for this committee. Mr. Gore, let's stipulate you have respect for the committee, and let's just talk theoretically about process. I won't ask you questions about your deliberative process. I won't ask you questions about the topic you refused to testify about. You indicated that it was a passionate commitment on the part of the Department of Justice to see that the laws we passed were vigorously enforced. Is that correct?
Yes, Congressman. Thank you for your question.
No, that's all right. I will stipulate you are grateful for all of our questions. Would you concede, of course, we have an equal interest in the vigorous enforcement of those laws?
Yes.
Yes. So, within reason, we have a right as a co-equal branch of government to inquire as to your efforts to vigorously enforce the law. Is that not fair?
Yes.
And is it your position that the Department of Justice unilaterally can decide when to cooperate with this co-equal branch of government in the exercise, constitutional exercise of its oversight responsibilities?
I don't believe I've said that or
No, I
taken that
didn't.
position.
I'm trying to extend the logic of your assertion about what you will and will not testify to. Is it, I'm probing that, where are the limits on that? In this case, you argue in a novel way that litigation is such a barrier. Pending litigation on a matter precludes your ability to cooperate with us on our oversight of the vigorous enforcement of a particular law. Is that not correct? Isn't that your assertion?
What I've said today is consistent with Department policy and
No,
practice. Litigation.
we'll stipulate your assertion of consistency. I'm trying to understand the principle behind it.
So there are a couple of
You're asserting that the Department of Justice gets to make rules with respect to your cooperation on our legitimate constitutional oversight role when it chooses, and one of those limitations is pending litigation.
Pending litigation is a limitation in these circumstances. Other limitations include the need for the Department of Justice to facilitate open and robust discussion before decisions are made. For that reason, the Department does not talk about deliberations or privileged conversations that might happen in an attorney-client context.
And Mr. Gore, if we decide we don't agree with you, if the Congress decides your assertion is in fact an encroachment on our ability to function constitutionally in our oversight responsibility, what remedy do you understand we have to dispute and to seek adjudication of that difference?
Congressman, I've not studied the issue, and I cannot take a position on that on behalf of the Department of Justice.
It is our ability to issue a subpoena, is it not? We could subpoena you.
It's my understanding that the committee has subpoena authority.
And what is your understanding of the
penalty?
And what is your understanding of the penalties that flow from non-cooperation with the subpoena issued by the United States Congress?
Again, Congressman, I've not studied the issue, and so I don't have a view one way or the other as to what the penalties are that are either prescribed by law or would be appropriate in any particular instance, and I can't engage in a hypothetical on that.
It's not hypothetical. I mean, it's a matter of law, Mr. Gore.
Well, certainly what penalties would be appropriate in any particular case.
You could be held in contempt.
That case happens,
you could be held in contempt of Congress, could you not?
Me personally?
Yes.
I'm not currently under a subpoena, Congressman.
No, I understand.
I'm generally aware that individuals
Mr. Gore,
can be held
Mr. Gore, let's not play games. I said one of the remedies available to us is a subpoena. You agreed with that.
I do agree with that.
And if you did not cooperate with that subpoena, remember I began by saying we're going to have a hypothetical conversation because you don't want to talk about the specifics. So hypothetically, Congress could hold you in contempt if you did not comply with the subpoena. Is that not correct as a matter of law?
I believe
Is it
that's
not
correct.
Congress's?
I believe that's correct as
That's
a matter
right.
of law, Congressman, and I'd be happy to talk about specifics of the Department's letter or other publicly available information, and I've answered several questions to that effect.
You've barely answered any questions, Mr. Gore.
I haven't been asked very many questions about publicly available information,
Well,
and I'd be happy to answer all of them.
because the Congress can decide what levels of inquiry and what layers of inquiry it wishes to pursue, Mr. Gore. You don't get to delineate that. We decide that. And you can decide whether to cooperate or not, and we can decide whether we can compel your cooperation. And that's what we're about to debate, I hope. Your lack of cooperation is very concerning because The census is actually stipulated in the Constitution of the United States. And I at least, hopefully you and I would agree on this, that we need full cooperation with the census in order to get a full picture of the country and in order to fairly adjudicate issues like representation here in the Congress, the allocation of federal funding for lots of programs. A lot is at stake. Would you not agree?
I do agree with that.
So we do have cause, legitimate cause, to be concerned on a bipartisan basis about how the census is conducted and whether any additions or subtractions from the questions asked in the census could materially affect cooperation with the census, both in cost and in accuracy. Is that not a fair concern?
Gentleman's time has expired. To the extent a question was asked, you may answer it.
The Congress generally does have an important oversight role to play in ensuring that the total enumeration of the census is accurate and done in a cost-effective manner.
The
Thank you, Mr. Chairman.
Gentleman from Virginia yields back. The gentleman from Arizona, Dr. Gozar, is recognized.
Mr. Gore, does the Department of Justice and Civil Rights Division have a memorandum of understanding with the Census Bureau and the Department of Commerce to receive this data?
That's a good question, Congressman, and I don't know the answer to it.
Are we able to get that outline, that MOU?
Again, Congressman, I don't know whether an MOU governs that relationship or if it's governed by some other provision of law, so I don't know.
Would you submit that to us once you find out?
I can't make that commitment today, Congressman, because I don't know what it is.
Are there any other privacy or other restrictions indicating how the data may or may not be used?
In fact, there are, Congressman. There are all kinds of restrictions on how the census data is used, and that's a message that's been consistent from the Department of Commerce and the Census Bureau throughout its decision to reinstate this question on the 2020 Census Questionnaire. By law, the Congress has enacted laws that prohibit the disclosure of individual responses to the census. So we would not see that information. It could not be used in any kind of immigration enforcement proceeding by the Department of Justice or any other department. The only data that's made available to us is aggregate statistical data covering census blocks in larger geographic areas. Individual responses are not provided to us. Those are kept confidential by the Census Bureau, and I understand that every employee who sees them agrees to some non-disclosure agreement and can't disclose those responses for the rest of their life.
So that's an important point again. So I'm going to ask that question again so you can repeat that so everybody can hear that. Any question in regards to citizenship that is answered in regards to the census, could it be used by any law enforcement agency or judicial proceeding by the government?
It could not be used. My understanding of the law, Congressman, is it could not be used in any immigration enforcement proceeding. It could not be used. I believe that those, it's my understanding that the individual responses stay at the Census Bureau. I know what we receive in the Civil Rights Division is only aggregate statistical data, and all of those individual responses are protected by law, and the confidentiality and privacy of individual responses on the census is protected by an act of Congress.
So once again, can't be used in a legal proceeding.
It certainly can't be used in an immigration enforcement proceeding.
Now, Mr. Gore, let me quote Ken Paxton, the Attorney General of Texas. Knowing the number of citizens in any district will help reduce voter fraud by providing a more complete picture of the eligible voters in a district. Let's say that there are 300,000 U.S. citizens in a district and 350,000 turn out to vote in an election. We would know there's a problem. Now, would you say, Mr. Gore, that voter fraud has occurred if there's more votes are cast than there are eligible voters?
I think if you had accurate data about the number of eligible voters and registered voters and the number of votes cast, it would certainly raise a lot of concern if the turnout in a particular geographic area exceeded the number of eligible and registered voters.
That would, if you're a data collector, something's wrong with that scenario, right?
It sounds like it as you've outlined the hypothetical, Congressman.
Now, would you say voter fraud has occurred if, let's restate that. Does the Civil Rights Division ever tally the total number of votes cast in a precinct and compare it to the eligible voters in the same precinct?
We have sometimes looked at that data to understand what states are doing to comply with the National Voter Registration Act, and in particular its requirements for voter registration and removing voters who become ineligible from the rolls. So yes, we have on occasion looked at that aggregate data.
Let me ask you a question. Do you know the difference between a census block group and a census block?
Yes, generally, yes.
Can you explain it a little bit?
Sure. The census block is the smallest unit of geography that the Census Bureau collects data for. It's generally the size of an urban or suburban block. It can be one apartment building or a small collection of homes. And a census block group is an aggregation of census blocks. It's a group of census blocks. I think on average it's about 39 census blocks per census block group, but it can be fewer than that and it can be a lot more than that. And so a census block group is a larger area of geography, and then several census block groups are put together to form what's called a census tract.
With my last question, I'm going to reiterate it because sometimes people are doubting Thomases. They have to hear things 3 times. So will responses to the 2020 census question or citizenship be used by the Department of Justice or any other law enforcement agency in any judicial proceeding against a respondent?
Congressman, it's my understanding that those individual responses cannot be used in any immigration enforcement proceeding. Moreover, the individual response that someone is not a citizen isn't really very probative of what their immigration status is. We have millions and millions of hardworking immigrants in this country who are non-citizens who entered legally. And they came here for the American dream. They're pursuing the American dream here through work, through school, through family. And so whether or not someone's a citizen doesn't tell you a whole lot about their immigration status, even if you could get that individual information, which the Department of Justice cannot, because the Congress has protected it from disclosure.
Thank you, Mr. Gore. I yield back.
The gentleman yields back. The gentleman from California, Mr. Gomez, is recognized.
Thank you, Mr. Chairman. Welcome, Mr. Gore. Let's just get into the questions real quick. Mr. Gore, did the Department of Justice express the need for citizenship data when the Census Bureau last conducted its content review?
I'm not sure when the Census Bureau last conducted its content review, Congressman.
Well, that was a no, but I'll give you the answer because it was last spring, and then they had the content review draft in November, but that's a no. Let's move on. The DOJ says it needs citizenship data to better enforce the Voting Rights Act. When was the Voting Rights Act enacted?
1965?
Yeah, correct, 53 years ago. Was a citizenship question included in the 1970, 1980, 1990, 2000, or 2010 census? Short form, across the board, not the long form, and not the American Community Survey.
It was not included in the short form those years. It was included in the long form from 1970 to 2000.
Thank you. The answer was no. Since the enactment of the Voting Rights Act, the DOJ has not deemed it critical to include a citizenship question on the short form, the entirety of the census. So, Mr. Gore, why did the DOJ why didn't the DOJ make this request in previous years, and what urgent reasons arose between 2016 and 2017 that required a last-minute change?
Congressman, thank you for your question. I was not at the Department of Justice in that prior time frame, so I can't speak to why or why not certain decisions might have been made by the department at that time. The letter that the department sent to the Census Bureau laid out the position of the Department of Justice today and why the census data information would be more suitable and more appropriate for Section 2 enforcement. Okay. Let me just be clear, Congressman. There's no dispute that the Department of Justice needs citizenship voting age population data to enforce Section 2, or that it needs that data at the block level. And our letter explains why hard count census data would be better suited for that purpose than the ACS. It's easier to use because it's already available at the block level.
Mr. Gore,
but it's more accurate because it's a hard count and not an extrapolation.
The point is that not having that data, right, did not undermine any lawsuit that was brought by the Department of Justice and the Voting Rights Act. So if you didn't really need it, right, to uphold, nobody said, hey, you didn't have the citizenship data at the block level, so, you know, your argument is weak. Then no one's ever said that. So let's move on.
Well,
Mr. Gore, would the Department of Justice mission be compromised if the citizenship questions were not added to the 2020 census?
Well, Congressman, what I can say is that we have been making do with the available data, which is the ACS estimates and extrapolations down to the block level, in addition to other data. The Department of Justice has not brought a case.
Can you answer that question real quick? Would the mission be compromised if the citizenship questions were not added?
As I've said, we are able.
Yes or no? I'm going to reclaim my time because I'm running out of time right now. Would the DOJ be unable to enforce the Voting Rights Act without this data?
Without accurate citizenship data, yes. And as I said, we have made do with the data that's available.
So the DOJ hasn't been able to enforce the Voting Rights Act for the past 53 years? Because that's what you're telling me.
Congressman, that's not what I said. What I said is...
No, but that was the question. Would the DOJ be unable to enforce the Voting Rights Act data without this, the Voting Rights Act without this data? That's the question. So the answer is no, because you've been doing it for 53 years before this year. So let's move on, because I only have a minute left. Attorney General Sessions in April testified before the Senate regarding the citizenship question. During his public testimony, he said, "People don't have to answer it. Really, I would think that's a very reasonable thing. I think concerns over it are overblown." Mr. Gore, is the Attorney General encouraging people not to respond to the census or the citizenship question?
Congressman, perhaps what the Attorney General was referring to is the fact that the Census Bureau will count incomplete census questionnaires in the total enumeration. So if for some reason the person filling out the questionnaire doesn't answer a particular question, it still counts.
Mr. Gore, I appreciate that. Real quick, did Stephen Miller contact the Department of Justice about adding a citizenship question? Do you have any emails, phone records, letters, communications with Stephen Miller from the White House?
Again, I'm not going to get into any department communications or deliberations that may have happened in the executive branch or any decision.
Thank you,
about
Mr. Gore.
This or any other matter.
Gentleman yields back. The gentleman from Michigan is recognized.
Thank you, Mr. Chair. Thanks for being here today, Mr. Gore. Unfortunately, sometimes it degenerates here rather than ask questions, that the witness has become a piñata in order to make a political point, and in my opinion, today is an example of that. The importance of the census is making sure people are comfortable enough answering questions that their privacy is protected. They don't feel vulnerable. Otherwise, you have a real faulty census. So that's just questions about privacy. When was the last time the Department of Justice brought a case against someone for unlawfully disclosing information in violation of the privacy laws in Title 13, the census? Do you recall when the last time that was?
I don't know.
So you don't recall cases where suddenly people's privacy has been violated?
I don't know of any.
What are the penalties levied against people found guilty of violating Title 13 privacy laws?
I've not studied the issue, Congressman. I don't know what those penalties are off the top of my head.
Okay. Has the Department of Justice, in your knowledge, ever brought a case against a person for failing to complete the census and return it?
I've not studied that issue, Congressman. I don't know. I'm not aware of any recent case in that regard.
Looking forward to the 2020 census, does the Department of Justice have any enforcement plan for individuals failing to complete and return a census form?
That would not be, any enforcement would not happen by the Civil Rights Division. So I'm not aware of one. I can't speak to whether there is one or not.
What if a person leaves a blank question and returns it? What happens?
That was the question I was just answering before. The Census Bureau does count incomplete questionnaires. So if a question is left blank or the answer is unintelligible for some reason, it's my understanding that the Census Bureau still counts that information on the questionnaire as part of the total enumeration.
I asked it again because I'm not sure you got a fair opportunity to answer, which is why I repeated the question, because I didn't think you had a chance. You know, I'll honestly admit, I've done that terrible thing. I've left questions blank on the census, and no one knocked on my door. I didn't get a letter saying, why did you do such a terrible thing? So I appreciate your being here. I'll yield back, Mr. Chair, as I don't have a lot more to ask this gentleman.
Would the gentleman yield? Would the gentleman yield the remaining
time?
time?
Back to the chair.
The gentleman from Massachusetts is recognized, Mr. Lynch.
Thank you, Mr. Chairman. Mr. Gore, obviously the spirit in which we brought you here was one that's pursuant to congressional inquiry. The right of Congress to make inquiries and investigations into the executive branch, you know, is a constitutional protection for the American people. And your position here is hostile to the protection of the rights of the American people, in my opinion. The United States Supreme Court has held in multiple cases that any congressional committee which is engaged in a legitimate legislative investigation need not grind to a halt because of an ongoing litigation or some distinct proceeding. So this is round one. This is round one. I think the American people, on this basis as well as others, will demand full exercise of their rights to be protected by Congress. Is there any basis in law in which you believe or you've been instructed that would prohibit you from participating and cooperating in this hearing?
Congressman, thank you for the question. I have cooperated and participated in this hearing to the
You haven't answered any questions.
I've just answered several questions, Congressman, and I'm happy to speak to any questions about public information.
Okay, well, tell us then. Again, I'm going to repeat the questions that you dodged earlier. Who came up with this decision to add this question to the census?
Congressman, the letter that the Department sent represents the Department's final decision and statement of position with respect to this issue. Similar to how a congressional staff works, you facilitate robust and open conversation with your staff, and decisions are made through an open and fair process. And that's what we do at the Department of Justice as well. So
but the decision comes from a member.
Certainly. And
we're empowered. And so we're asking you, don't just push it off on the staff came up with this idea. Someone with authority in the Trump administration came up with this decision. Apparently, you're very embarrassed by it because no one wants to take credit for it. There has been nothing but obfuscation from the administration, including yourself, when we ask this question. We don't have the power to prosecute. We have the power to ask questions. And I believe the American people deserve those answers.
Congressman, the Department of Justice laid out its position clearly in the letter as to why it was requesting this information.
So this was...
it described the reason we need that information for...
This is Attorney General Sessions you're talking about.
It represents the view of the Department, so I believe the Attorney General agrees with that view, yes.
Okay, well, there's part of an answer.
Speak for him personally, but yes, obviously a decision like this is made in consultation with appropriate stakeholders at the Department. That I'm happy to talk about and confirm. I don't think that's particularly earth-shattering. That's the process that happened. But yes, the letter represents the view of the Department, and the Department stands by that view. The letter was sent to the Census Bureau and the Department of Commerce. I understand from publicly available information that the Secretary of Commerce, Secretary Ross, took a hard look at the request, did an independent analysis of it, considered various options as to how to provide block-level citizenship data to the Department of Justice for
I have 1 minute left.
Enforcement work, and
Mr. Chairman,
that's how the decision was made.
Reclaiming my time. Mr. Chairman, we need the support of the chair in order to get to the basis of this decision. We think it's important to the American people. Obviously, as the chairman, you have great sway under our system of rules on this committee, and I would hope that you would see clear to support this very reasonable request on the part of the minority members of this committee and support the issuance of this subpoena. With that, I yield back.
The gentleman from Massachusetts yields back. The gentleman from California is recognized.
Thank you, Mr. Chairman. Mr. Gore, I'm going to start off by admonishing you for not being here at the previous hearing. That was an error that likens back really to, harkens back to the last administration that showed a level of disrespect from the Department of Justice. And much of that continues today at the Department of Justice, where in case after case, we're not getting in a timely fashion information, and the highest level of classification is often being used as an excuse. And as we know, the highest level of classification in the Department of Justice is embarrassing. The last Attorney General before last actually claimed a privilege on what turned out to be text back and forth to his wife. So I hope that this is the last time that we have to have 2 hearings to get 1 hearing. Now, having said that, I would join with some of my colleagues in a round of questioning about the core of the decision to find out, for the purpose of civil rights compliance, how many people are eligible to vote in a particular block, in a particular congressional district. And I'll start off by telling you a very short story. A few months ago, approaching a year ago, I had a longtime resident of my district, a father of several children, one of them already over 21, arrested as he tried to enter Camp Pendleton at a job he'd been at for more than a decade, almost 2 decades, and he was a supervisor. And he was apprehended because, in fact, he was undocumented and he had falsified documents related to getting on the base. It was a sad situation. He'd been here since 1989. When I tried to do what I could for the family, as we often do in casework, I went to the voter rolls. I found him, I found his wife, and I found 1 adult child. The adult child was born in the United States. The wife was not a legal resident and had entered illegally in 1991. He had entered illegally in 1989. They were both registered voters. Now, I will tell you, it appears as though they never voted. But in California, without a doubt, there are tens or even hundreds of thousands of people who do not want to say no to the motor voter, no, I don't want to be registered to vote, because they're afraid that will tip off that they're undocumented. So I'm going to ask you, if not for a census, where my Democratic colleagues, if they operate in good faith, and Republicans, if they operate in good faith, would echo what you said earlier, which is this information is never disclosed. It is used only for the statistical purposes in aggregate. If not for your census question, wouldn't we have the same situation in California where the number of registered voters, thus eligible either to vote or for others to vote on their behalf, could in fact lead to a different outcome in an election?
Congressman, thank you for your question. First, let me just address the issue I already addressed in my opening statement, which was the Department's explanation for why I didn't appear at the hearing last week. It's because a non-government witness was included on the panel.
And that is, in fact, a decision that this committee has, over the years, pushed back. We've had negotiations, and the chairman's a good negotiator. We could have potentially had a second panel, but it is not for the Department of Justice to simply say, we're not showing up if we don't get what we want, because the last administration, in some cases, objected to somebody because they, even though they were in the government, they weren't at quite the right level. So I don't accept that. As a former chair of this committee, I don't accept that, and I would hope that you would take that back to your higher-ups, that there are better ways to resolve that with this committee and with a very reasonable chairman than to simply not show up. But go ahead with your answer.
Thank you, Congressman. On the issue that you've raised, I've not studied the issue of the voter rolls in California, so I can't speak specifically to
Well, let me just give you a brief one in the remaining time.
Sure.
California has no documentation whatsoever. A person shows up and gets a driver's license. They do not have to prove that they're in any way a resident or a citizen, and the default is they end up with being registered voters. Our voting system has no ID. As a matter of fact, if you show up at a poll, you cannot be asked to show ID, and in fact, if you try to show it, they make you put it away. But please continue with how this would impact elections if, in fact, you have tens of thousands of people registered that are, in fact, not citizens, but afraid to say so because it's not like the census, it's not secret.
Obviously, Congressman, thank you for your question. If there are large numbers of ineligible persons, in fact, casting ballots at the polls, yes, obviously that could have an effect on the outcome. There are plenty of examples of close elections throughout American history that could have turned on that difference.
Thank you. Thank you, Mr. Chairman.
Gentleman yields back. The gentlelady from Michigan is recognized. Gentlelady from Michigan is recognized.
Thank you, Mr. Chair. In the 11 months the Bureau have not had a permanent director, the administration considered placing a partisan redistricting expert, Thomas Burnell, at the helm. Mr. Burnell himself recently admitted that this census is being politicized. In an interview with Science magazine, he said, and I quote, "They have made a political decision, and they have every right to do that because they won the election." Also, President Trump has been campaigning on the addition of the citizenship question. An ad sent by his campaign to his supporters reads, and I quote, "President Trump has ordered the 2020 United States Census ask people living in America whether or not they are citizens. But now the sanctuary state of California is suing him. It's time to fight back." This seems to me like a political decision has come from the top, and we have asked you, and I will ask again, exactly who in leadership made this request? Was it the Attorney General Sessions? Who specifically was it?
Congresswoman, as I said before, I can't get into the specifics of the deliberations or decision-making of the Department of Justice. I can confirm again that the letter represents the position of the Department, and all decision-makers signed off on that decision, including the Attorney General. To get to the premise of your question about Mr. Brunel, I don't believe anyone's had any conversations with Mr. Brunel about it. I certainly haven't. He's a private citizen. He's not a member of the Department of Justice. He doesn't speak for the Department of Justice. He's not a member of this administration. He doesn't speak for this administration. I have no idea where Mr. Brunel's getting his information from or how he's drawing his conclusion as to what he thinks was the motivation for the request to add this question to the citizenship
Well, it seems from your answer that you don't know where Mr. Burrell gets his information, and you also don't know where your information and your guidance is coming from, because based on your statement, how you keep answering the question, I don't know where it came from, I got a random letter. So you're sitting here today saying that I don't know how things happen, I don't know who makes decisions, it just kind of happens. It's like soup. You just throw things in there, and then all of a sudden we have soup. It does not appear that you are an expert witness. Can you help me with that?
Congresswoman, I haven't said that I don't know. What I've said is that the Department of Justice, by longstanding policy and practice, does not discuss internal deliberations or decision-making. I think I've said now a couple of times that the Attorney General signed off on the decision. Beyond that, the Department's position is stated in the letter. Let me just speak to the campaign email that I think you read from, Congresswoman. I've never actually seen that email. I had no communication with the campaign regarding this or any other matter, and so I can't speak to that.
Mr. Gore, will you confirm here today that the Department of Justice will follow the law in abiding by the protections provided by Title 13 and complying with the prohibiting against sharing individual census requirement? Will you be on the record today under oath saying that the Department of Justice will follow the law?
Yes.
So in any case, and I'll say this to our chair, I will let you know that the American Arab Association in my community has stated many of the members of the Arab American organization will undoubtedly refuse participation in 20 census, primarily out of fear and suspicion that by answering the citizenship question, they will be singled out. I am saying to this chair and to this body and to you, Mr. Gore, someone has been misguided. It is not good enough to make a decision and go forward when you know the consequences of it. You can say you don't know how you got here, but now that this is being proposed, it needs to be addressed. We have tried repeatedly to make you understand that the constituents of this country who the Department of Justice works for You're here because of the taxpayers paying your salary, sir, that you need to listen to the people. And this question, and I will repeat again, is not one that is serving the objective and the outcomes that we need for a census count in our country. I yield back.
Gentlelady yields back. The chair will now recognize himself for questions. Mr. Gore, if I understand the argument correctly, both the asking and the answering of this question will help the department enforce the Voting Rights Act.
That's correct.
All right. So how has the failure to ask this question in the past hampered those efforts?
Thank you for your question, Congressman. It's undisputed that we need citizen voting age population data to enforce the Voting Rights Act in certain cases, and that we need it at the block level. We so far have been making do with the ACS estimates and other sources of information to try to extrapolate down to the block level what the citizenship rate would be in a particular area. We already get total population and racial data from the census, so we have that information already. But we have to make an educated guess about what the citizenship rate is at the block level. And having it on the census would make it easier for us to use, and it would also make it more accurate, or at least that's the judgment of the Census Bureau. I'm aware of at least one case that was brought by a private plaintiff, the Benavides case in the Northern District of Texas, where that plaintiff wanted to rely solely on the ACS estimates to prove a citizenship rate, but the geographic area was too small for the ACS estimate to be reliable. So the court threw that case out and said that this data, this ACS estimate, it was a one-year estimate, and the area was fewer than 65,000 people, and the Census Bureau says that at that small size of a population, the ACS estimates just really aren't reliable, at least the one-year estimates. So for that reason, that particular Voting Rights Act case was thrown out by the district court. We'd like to avoid that fate. We'd like to be able to bring every Voting Rights Act case that falls within our statute. That's our mandate from the Congress, and that's what we would like to do. And so, particularly when you're dealing with smaller geographic areas and smaller numbers of people, the ACS estimates are not sufficiently reliable. At least in that case, we're held not to be sufficiently reliable.
Well, Mr. Gore, that's why I foreshadowed my questions last week. I'm not trying to trick anybody, not trying to surprise anyone. I do think it's relevant whether or not past litigation has been impacted by the failure to include this information. You cited a case in Texas. Are there other instances where this information would have helped either a court or any other deciding tribunal litigate Voting Rights Act cases?
I'm not aware of any other case that was actually filed in which that has made a difference. And I will say that, again, the other rationale is that the census data is a lot easier to use because it would already come in the right format. We wouldn't have to run any extrapolations from the ACS estimates to get down to the block level. And it would come as the same data set that redistrictors use all across the country to draw maps, which is the census data that they already receive to comply with the equal population requirements of the Constitution.
Let me ask you a broader legal question. Who gets to decide whether or not a question is legitimate to include on the census form?
Congressman, I believe that the Congress has left that decision to the Secretary of Commerce, if I understand the statute correctly, but I'm not an expert in that, and obviously I can't speak for Secretary Ross.
What would the standard of review be?
I think that's a very good question, Congressman. I think it's one that's at the heart of the litigation. I don't know what the answer to that question is, and I believe the litigation is largely going to be about that question.
So if Secretary Ross wanted to include a question, what's your favorite movie, how would a court determine whether or not that was an appropriate question? I mean, I guess what I'm getting at is, what is the standard by which you judge the legitimacy of the inclusion or exclusion of a question on the census form?
I think that's a very good question. It's probably better directed to the Commerce Department. I'm not involved in the litigation that's being handled out of
No, but you're a lawyer, and you're familiar with the different standards of review and whether or not it's abuse of discretion, whether or not you have to have a reasonable public interest, whether or not you have to have a compelling public interest. I mean, you're familiar with all that.
I am familiar with all that, Congressman. I don't know how all of that intersects with this particular case. And as I said, that matters in litigation, and those are questions that are all going to be presented in the litigation, and I think it would be inappropriate for me to speculate or comment on that today, since I'm not the department's representative in that litigation.
Mr. Chairman, will you yield for a split second question? You don't, I mean, it's
No,
your prerogative.
I'm trying to figure out what a split second is, but yes, I'm happy to if you can keep to that split second.
Just to follow up, Mr. Gore answered to your question regarding the citizenship data. Said he said that the Department of Justice is making do with the data that they're getting, but when he answered my question, he said they can't enforce the Voting Rights Act without citizenship data at the block level. Can you? It seems contradictory to me.
Well, let me see if I can help you out. To the extent that there is any ambiguity in your answer to those two questions, would you like an opportunity to synchronize your answers?
I would like that opportunity, and thank you, Congressman Gomez, for raising the opportunity for me. When citizenship rates are at issue, we need data at the census block level. We're currently making do with the data that comes from the ACS, which isn't at the census block level, but we use extrapolations to make an estimate of what's going on at the census block level. So yes, we do need data at the census block level. Yes, we are making do with the currently available data to draw estimates as to what's going on at the census block level, whether it's the ACS data or a surname registration data or something else. Our letter lays out why the hard count census data would be more appropriate for that function because it's a hard count and it would be simpler for us to use, and the Census Bureau believes it would be more accurate.
Ms. Gore, I'm out of time, so I'm going to try to kind of harmonize, I think, the different perspectives of my colleagues. When something's been done for a while and then it's not done, it raises questions, and people want to know why was the question removed, and then when it's reasserted, they want to know how did the exclusion of that question adversely affect you. So I'm not giving you litigation advice. You'd be crazy to take it from me. But in terms of the practical advice on how to answer questions for Congress, I think that is what folks are wondering, is we had the question for a while, then we had it in another form. What has been the impact of changing the manner in which that information was collected? And I guess the threshold question is, do you have to assert that it helps you enforce the Voting Rights Act to include the question, or could you just include the question because you felt like it? And if our position is, if the government's position is that it helps us enforce the Voting Rights Act, it'd be helpful to be able to point to specific instances where the failure to have that information may have hampered your efforts to enforce it.
Yeah, and Chairman, I'm happy to provide a response to that. As I've said, we've made a case as to why the census data would be more appropriate for enforcement of the Voting Rights Act, due both to the simplicity of its use and its greater accuracy than ACS estimates and extrapolations. I pointed to the Benavides case, which is a case brought by private plaintiffs who were unable to prove their case because the ACS estimates were too unreliable for the size of population involved there. As to whether that is sufficient to warrant including the question on the citizenship or on the census questionnaire is a question that I think the courts are hashing out in the pending litigation.
Before we vote, I'm going to let the ranking member ask one question. I do want to thank all of my colleagues on both sides for coming for an unexpected vote on what I know is a very busy morning anyway. So as soon as Mr. Cummings asks his question, we are going to move to the vote, and I appreciate
Thank you very much. Thank you very much, Mr. Chairman. Mr. Gore, I just listened to the questions that the chairman asked you, and they're very good questions, as you agreed. And it seems like all this is based upon the Voting Rights Act, a lot of it. But I just want to have your opinion on this. DOJ has not filed a single voting rights action during the entire tenure of the Trump administration. Attorney General Jeff Sessions has called the Voting Rights Act, quote, intrusive. During the Trump administration, DOJ has reversed its position in 3 voting rights cases, one on gerrymandering in Texas, one pertaining to a voter ID law in Texas, and one on a voter purging in Ohio, all in favor of voter suppression efforts. DOJ updated the U.S. Attorney Manual to remove prior references to racial gerrymandering. President Trump repeatedly and falsely accused millions of legitimate voters of committing voter fraud by voting illegally for Secretary Clinton. President Trump established a commission in January 27 to try to identify evidence to support his false claimed that millions of U.S. citizens voted illegally. And finally, President Trump selected as the chairman of his new commission, Kansas Commissioner Chris Cobart, who was held in contempt last month for failing to inform state voters of their eligibility to register after a court blocked a 2016 law requiring proof of citizenship. My question is, I want you to understand why some of us may be skeptical when folks say that they're doing this so that people like my mother, who years ago could not vote, and even today. Do you understand that, why we might be skeptical?
I understand where you're coming from, Congressman. I do. And I'd like to, if I might have a moment, just respond to your question, because there are several things in your question that I think are not accurate, and I'd like to be able to correct those on behalf of the Department so that you, Congressman, and the entire committee and the entire Congress and the American public understand what's going on. So, for example, we have filed a voting rights action. As I mentioned in my opening statement, we filed an action involving the state of Arizona under UOCAVA to protect the voting rights of military voters and other overseas citizens. In terms of Section 2 of the Voting Rights Act, we have continued to participate in 3 Section 2 cases since January of 2017. And our enforcement efforts under Section 2 are completely in line with the enforcement efforts of the Obama administration. In its first 4-year term in office, the Obama administration filed 1 case under Section 2 of the Voting Rights Act. It filed that case in early 2009, meaning that the investigation had been conducted under the Bush administration. It filed no Section 2 case in 2010, 2011, or 2012. It increased its number slightly in its second term. In 2013, it filed 3 cases, but it filed none in 2014, none in 2015, and none in 2016, and it filed 1 on its way out the door in January 2017, which we have continued to litigate on behalf of the United States. So the amount of Section 2 activity we have is completely in line with what the Obama Justice Department did. In 6 years in which it was in office, it never filed a Section 2 case. Moreover, it had an opportunity to do so because every state in the Union was required to redistrict after the 2010 census. The question about gerrymandering in the U.S. Attorney's Manual, that was a change that was suggested by the career prosecutors in the Civil Rights Division because that provision is already subsumed in another provision within the U.S. Attorney's Manual, and there's an effort to simplify and streamline that manual. It represents no change in policy or practice by the Department of Justice, as the Deputy Attorney General has already explained publicly. And in fact, we participated in a racial gerrymandering case in the Supreme Court in April. We also have not changed positions in 3 voting rights cases. There's 1 case in which the Department changed a position, and that case is currently pending before the United States Supreme Court. I think the 2 other cases you're referring to are 2 cases out of Texas. And in those cases, the Department didn't change its position. Texas changed its law. Texas changed its voter ID law to address the defects that had been alleged in that case. It passed an entirely new statute to do so. And in fact, that statute largely tracked the district court's own interim remedy that it put in place for the 2016 election. And in 2016, nearly 9 million Texans voted, and there was no suggestion and no evidence brought to the court that the voter ID law had resulted in any vote suppression. 3 weeks ago, the Fifth Circuit Court of Appeals agreed that that law was sufficient to remedy the defects, and it overturned the judgment of the district court. I think you've also referred to the Texas redistricting case. Again, Texas adopted a new redistricting plan. The United States hadn't previously taken a position on that plan. And in the Supreme Court, what we argued to the court is that Congressional District 35, represented by Congressman Doggett, is an appropriate district under Section 2 of the Voting Rights Act. As I said before, I've not communicated with Mr. Kobach. I think I may have met him once. We had no consultation on this or any other issue. I appreciate where you're coming from, Congressman. I hope that I've been able to provide some facts that will help you understand where we're coming from, and as we try our best in the Department of Justice and in the Civil Rights Division to carry out all the laws that the Congress has enacted and enforce them to the best of our ability. And we will continue to do so because that's our mission, that's our charge under the Constitution, that's our charge from this Congress, and we take very seriously that responsibility, and it's my honor to serve in this capacity for some period of time with the hardworking career professionals in the Civil Rights Division.
Gentleman from Maryland yields back. A quorum being present, the committee will resume consideration of the gentleman from Alabama's motion to table the motion of the gentlelady from New York. Those in favor will signify by saying aye. Aye. All those opposed signify by saying no.
No.
In the opinion of the chair, the ayes have it. Recorded vote being requested. The clerk will call the roll.
Mr. Gowdy?
Yes.
Mr. Gowdy votes yes. Mr. Duncan? Mr. Duncan votes aye. Mr. Issa? Mr. Issa votes yes. Mr. Jordan? Mr. Jordan votes yes. Mr. Sanford? Mr. Sanford votes aye. Mr. Amash? Mr. Amash votes yes. Mr. Gosar? Mr. Desjardins? Mr. Desjardins votes yes. Ms. Fox? Ms. Fox votes yes. Mr. Massey? Mr. Massey votes yes. Mr. Meadows? Mr. Meadows votes yes. Mr. DeSantis? Mr. DeSantis votes aye. Mr. Ross? Mr. Ross votes yes. Mr. Walker? Mr. Walker votes aye. Mr. Blum? Mr. Blum votes aye. Mr. Heiss? Mr. Heiss votes aye. Mr. Russell? Mr. Russell votes aye. Mr. Grothman? Mr. Grothman votes aye. Mr. Hurd? Mr. Hurd votes aye. Mr. Palmer? Mr. Palmer votes aye. Mr. Comer? Mr. Comer votes yes. Mr. Mitchell? Mr. Mitchell votes aye. Mr. Gianforte? Mr. Gianforte votes yes. Mr. Cummings?
No.
Mr. Cummings votes no. Ms. Maloney? No. Ms. Maloney votes no. Ms. Norton? No. Ms. Norton votes no. Mr. Clay? Mr. Lynch? No. Mr. Lynch votes no. Mr. Cooper?
No.
Mr. Cooper votes no. Mr. Connolly?
Nay.
Mr. Connolly votes nay. Ms. Kelly?
Nay.
Ms. Kelly votes nay. Ms. Lawrence?
Nay.
Ms. Lawrence votes nay. Ms. Watson-Coleman? Mr. Krishnamurthy?
Nay.
Mr. Krishnamurthy votes nay. Mr. Raskin? Mr. Raskin votes nay. Mr. Gomez? Mr. Gomez votes no. Mr. Welch? Mr. Welch votes no. Mr. Cartwright? Mr. Cartwright votes no. Mr. Desaulniers? Mr. Desaulniers votes no. Ms. Plaskett? Mr. Sarbanes? Mr. Sarbanes votes no.
The clerk will report.
On this vote, there are 22 ayes and 15 noes.
Motion to table passes. We will now, I want to again thank all the members on both sides for coming, and we will resume with our questioning of the witness until votes are called, and we're over here, so give me 1 second. The gentleman from Illinois is recognized.
Thank you, Mr. Chairman. Good morning, Mr. Gore. Many individual citizens as well as non-citizens, including legal permanent residents, are fearful about giving their personal data to the government, particularly in the current political climate. These fears were escalated recently by the DOJ's request to include the citizenship question on the 2020 census. That is why I think it is so critical today for us to remind individuals that Title 13 protects the confidentiality of their census responses and prohibits the government from sharing the data with other government agencies. Mr. Gore, will you confirm here today that the Department of Justice will follow the law in abiding by the protections accorded by Title 13 and complying with the prohibitions against sharing individual census responses? Absolutely, Congressman. I can confirm that. And I would like to reiterate something I said before, which is that we take our duty to enforce the law very seriously, and we think that no one should have fear in responding to the census questionnaire or to the citizenship question if, in fact, it is included. First, for the reason that you lay out, which is that that data, the individual responses, are protected by law and can't be disclosed. But also, Congressman, let me just reiterate that whether someone's a citizen or not doesn't tell you a whole lot about their immigration status. There are millions and millions of hardworking Americans who are non-citizens who are in the country legally. Thank you. Will you affirm that
the Department of Justice has no intention of obtaining confidential data or using it for any other purpose, including sharing it with any other federal law enforcement agency or any other agencies?
What I can tell you, Congressman, is that with respect to this data or any other data, the Department of Justice will abide by all legal requirements.
Okay, so are you saying that there is a possibility that you may share this data with other federal agencies?
Again, what I'm saying, Congressman, is I don't know exactly what the parameters are of the restrictions on use of this data, but whatever they are, the Department of Justice will abide by them. It's my understanding, I can't speak on behalf of the Department because it's not one of my responsibilities to determine what happens with this data, other than the data that's shared with me. But I can say unequivocally that on behalf of the Department would comply with all legal requirements.
So do you conceive of a situation where it may be legal to share this data with other agencies?
I can't conceive of that kind of situation from the Civil Rights Division perspective, which is where I work. I don't know what goes on in the rest of the department and what the law is, but the Department of Justice will follow the law.
Okay, so you don't know what the law is with regard to the sharing of this data?
I do know that there are prohibitions on the sharing of the data. I don't know how other entities within the Department of Justice deal with that issue, so I can't speak on their behalf. But I can speak on my behalf. I can say that all entities of the Department of Justice will follow the law, and I will say that within the Civil Rights Division, we do not share that data with other government agencies.
Let me shift to another issue, which is the DOJ aware of any study, analysis, or projection of how the inclusion of this citizenship question will affect the response rate for the census?
That's a great question, Congressman. I don't know that the Department of Justice is aware of that. That's really a question for the Department of Commerce and the Census Bureau, since it is the Secretary of Commerce's province to decide which questions get included or not within the bounds set by the law. My understanding is that from Secretary Ross's memos that he took a hard look at that issue and didn't find any empirical evidence to suggest that the question would lead to a reduction in response rates. That's based on the memo of decision that he issued. I obviously can't speak on his behalf.
If evidence were brought to your attention that the inclusion of this citizenship question would actually lower the response rate, how would you process that evidence as a member of the DOJ?
I think as a member of the Department of Justice, well, let me say this. I believe whatever evidence was presented to the Department of Commerce was considered. I can't speak to that again. I can't speak on behalf of the Department of Commerce. If that was brought to our attention, I think we would take a look at it. We are not the decision maker with respect to whether questions are included on the census questionnaire or not.
But let me ask you this. Well, thank you for saying that you would take a look at it. We intend to present you with that evidence. As the chief civil rights lawyer for the Department of Justice, if that evidence were to show a disparate impact in how minorities were counted for purposes of the census, would you then look at whether or not some kind of legal action would need to be taken with regard to the census?
Gentleman's time has expired, but you may answer the question.
I think we would take a look at it. I don't know whether legal action would be warranted, and I can't engage in a hypothetical of whether it would be.
Great. We will present you with that evidence. Thank you.
Gentleman yields back. The gentleman from South Carolina is recognized.
Thanks, Chairman. But in fairness to my colleague from California, I don't think he finished his line of questioning. I'll yield my time to him.
Thank you. And Mr. Gore, I'd like to pick up a little bit where I left off because I think this is extremely important. In a republic, in a democracy, isn't the sanctity of the vote perhaps the most important part of civil rights that we've spent decades, actually more than a century, going from denying people a vote because of their gender or their race to ensuring that all persons eligible or are eligible if they're citizens?
Absolutely.
So when you look at the other questions, have you looked at some of the other draft questions on the census?
I have.
Other than the first question, which is how many people live in this house, is there another question that is as important to our republic as this one?
I think that's a value judgment that reasonable minds can disagree on.
Well, let me ask it a different way. Constitutionally, we all understand that the census is required every 10 years for one and only one purpose, to find out how many people are here. So, and I dealt with this last week with the census people themselves. Isn't it true there really is only one question that's constitutionally mandated, and all these other questions are based on our country's belief that knowing this will advance the greater good?
I think that's correct, Congressman. And in fact, I would point out that other questions are asked, but the census remains a total enumeration. There's a question about sex, but people of all sexes are counted. There's a question about race, and people of all races are counted. And if there's a question about citizenship, people of all citizenship statuses would be counted as well.
And you did a good question there, because, for example, we're asking if you're Hispanic. Nobody's objecting to it, apparently, from the Democratic side. But, you know, it's, it goes into Mexican, Chicano, Puerto Rican, Cuban, all the reasons you might be a yes or a no. And nobody's objecting to it. But in fact, race it's good to know, but it's not essential to know for constitutional purposes. Here's another one: relationship. How is the person related to you? If you answered you had multiple. And questions are father, mother, opposite sex, unmarried, same sex, son, adopted son, stepson. Let me ask you, if you look at all the things that might cause someone to say, I'm going to just throw this in the trash, or I'm just going to mail it back, wouldn't asking somebody about what their, to be honest, sexual relations are, which is what that particular question leads to, aren't these all questions which could reduce the turnout from the basic turnout of how many people are in this house? Isn't that a risk we take with every question?
Congressman, I believe that would be a risk with any question. Whether, in fact, that plays out would be a question for the Department of Commerce. But I think I think that's correct.
And I will tell you that the Secretary of Commerce has put incredible time personally, along with his undersecretaries, into this, that he's been working it for a long time. But I'll go back to the initial question, because I think that's what this part of the hearing is all about. No one seems to care if you want to find out in the census whether somebody's straight or gay. That seems to be not controversial to my Democrat friends, and yet asking someone whether they have a right to vote so you can determine what the maximum count would be in a particular precinct, in a particular block, seems to be a problem. Why is it that that which goes to the core of our democracy seems to be a less important question to my colleagues than the question, quite frankly, of gender preference?
Congressman, I think that's a very good question, but I obviously can't answer, but we've been wondering the same thing, or I've at least been wondering the same thing, given the reaction to the request the Department of Justice made and the decision that Secretary Ross made.
Okay, now I want to use the remaining time that I've been loaned here to just make the history straight. This question was asked during Franklin Delano Roosevelt's time, and this is a historic question, isn't it?
It is.
And this is in the community survey as we speak, right?
Yes.
So the difference between having it in the main census and having it in the community survey, which apparently my colleagues don't object to, would seem to be a volume, correct?
I guess, yeah.
So it's the greater number of people asked a question, because I got the community survey, and I will tell you, it tells me on penalty of everything terrible happening in my life, I must answer it. So last question. If we are simply getting more people answering the same question that's been asked again and again in the community survey, isn't it that we simply get the ability to understand more clearly where and how many people should be able to be eligible to vote and receive services of that sort?
Yes.
Gentleman's time has expired, but you may answer the question.
Yes.
Thank you.
Gentleman from California yields back. Gentlelady from Illinois is recognized.
Thank you, Mr. Chair. The law governing the addition of questions to the census says that the Secretary of Commerce must submit proposed subjects to Congress 3 years before Census Day, followed by the actual questions 2 years before Census Day. That law also states, and I quote, if the Secretary finds new circumstances exist which necessitates that the subject's types of information or questions contained in reports so submitted be modified. A report containing the Secretary's determination of the subject's types of information or questions as proposed to be modified must also be submitted to Congress. The Secretary of Commerce did not include a citizenship question in the subjects submitted to Congress in April 2017, but in April of 2018, just 1 year later, he chose to add a citizenship question to the specific questions he submitted to Congress. Under the law, in order to do that, he must have encountered new circumstances necessitating that the subjects be modified. What are the new circumstances that necessitated this change?
Congresswoman, appreciate the question. I don't work for the Department of Commerce or the Census Bureau or the Secretary of Commerce, so I can't speak on their behalf.
So you have no idea why this occurred?
Well, I believe, based on publicly available information, that the Secretary of Commerce took a look at this in response to the DOJ request for the census block level citizenship data. Beyond that, I don't know what the thought process was because I don't work there and can't speak on their behalf.
But what I just quoted from what I just quoted from the law, do you think he was in his purview to do that, or do you think he followed the law?
I don't think it would be appropriate for me to answer that question because that question's in litigation.
Okay. The Voting Rights Act has been in place since 1965. So has the census. They didn't change. So you're saying that you don't know the new circumstances. Did the Department of Justice cite any evidence of voting rights cases to Secretary Ross that would have necessitated the addition of a citizenship question to the 2020 census?
To be clear, what I said was I don't know the circumstances or the thought process that went on at the Department of Commerce or the Census Bureau. I believe what so I didn't say I didn't know what was going on in the Department of Justice's letter. Our letter laid out the reasons why we think that a hard count census data at the block level would be more appropriate for use in redistricting cases than the American Community Survey estimates and extrapolations down to the block level. It would be simpler for us to use. It would be a hard count. It would align in time with the other census data that redistricting map makers and map drawers and courts and the Department of Justice already use. And the Census Bureau and Department of Commerce have made a determination that they think it would be more accurate. Beyond that was the evidence. That was the statement that we made in our letter, and the Department of Commerce, it's my understanding, took a hard look at that and made that determination.
Okay, well, just in conclusion, it seems like the only circumstance that has changed since 2017, the 2017 report, is who's sitting in the Oval Office, and unfortunately, that's not sufficient under the law to allow a new and untested question to be added to the census. I yield back.
The gentlelady yields back. The gentlelady from New York is recognized for a unanimous consent request.
I request a unanimous consent to place in the record a statement from the Asian Americans Advancing Justice Organization.
Without objection.
Thank you.
I believe all members present have been able to have their questions answered to the extent you're able to answer them. The hearing record will remain open for 2 weeks for any member to submit a written opening statement or questions for the record. If there's no further business, without objection, the committee stands adjourned.